And we're moving on to the United States, where we'll talk about some issues of religious liberty, religious freedom, and some, some of the bigger questions facing the United States today. I want to briefly introduce everybody. We have Kay Heelan-Gaston, who is a lecturer on religious history at Harvard Divinity School and is the author of Imagining Judeo-Christian America, Religion, Secularism, and the Redefinition of Democracy. Daniel Mack, who is the director of the ACLU program on freedom of religion and belief. And Mark Movsesian, who is a professor of contract law and co-director of the Center for Law and Religion at St. John's University School of Law. And Asma Uden, who is a religious liberty lawyer, scholar, and her books include When Islam is Not a Religion and the Politics of Vulnerability, How to Heal Muslim-Christian Relations in a Post-Christian America. And she's worked for Beckett, the Fund for Religious Liberty. So this is a great range of panelists and a great range of views. I want to start with a semi-rapid fire question, which is really just as we kind of pivot from France tangled up in its questions of religion and national identity to the United States with its questions of religion and national identity. I want to just ask each of you if you could tell us what you think are some of the biggest religious liberties issues facing the United States today, and then we'll kind of dive into some of them. So why don't we go in alphabetical order with Heelan, then Dan, then Mark, then Asma. So take it away.
Okay, well, thank you so much, Rachel, for organizing this exciting panel, and I'm really glad to be a part of it. You know, it's interesting, that question. I mean, I think certainly with the school vouchers question, on the table, and the sort of fate of the many Blaines that have essentially kind of made it possible for the voucher system to continue to be a sort of bone of contention for, the past 30, 40, I mean, really since Everson and McCollum, these issues have been sort of percolating. But of course, with the voucher legality ruling in 2020, 2002, that's a big part of what has sort of fueled the continued concern about how to resolve this particular issue. And I think for me as an historian, that is a huge, huge question that has far-reaching implications, and one that I hope we'll get a chance to talk more about. Also, the question more broadly of religious liberty claims on the right, the issue of how much do I, with the deinstitutionalization of religion, have the right to move outside of an institutional religious context and think about my rights to belief in relation to things like making a wedding cake, or giving contraception or the morning after pill to someone who, in my capacity as a pharmacist, right? These kinds of questions are really about the deinstitutionalization of religion, and they are going to continue because of the way that the information age we're living in has changed the nature of institutions. So that's kind of where, from my point of view, I guess the big issues lie.
I'm next.
Yes, Dan, go ahead.
Okay, thanks. Sorry, I lost track of the order. Biggest issues. I think some of the biggest issues religious liberty-wise that are facing the US are, first, the Supreme Court's steady retreat from its prior embrace of the constitutional protection of the separation of church and state, which is a key pillar of religious freedom. And this comes up in a lot of contexts, including schools, which I assume we'll talk about later. And at the same time, I think it is problematic, the simultaneous expansion and distortion of the right to free exercise, which is the other half of the religious liberty equation, the other of the two religion clauses in the US Constitution. And this expansion is coming even in cases where the exercise of religion is harming other people. And I worry that this is upending longstanding important rules and principles and setting precedent that can be used to cause all sorts of damage, including to existing civil rights protections, rules against government-sponsored religion that go back to the founding of the nation, and even threats to health and safety measures, which again, I think we'll probably talk about. I also worry about what I see as something of a double standard in the way some of these cases have played out, which threatens to enshrine this kind of unspoken hierarchy of faiths, with some getting special treatment and others occasionally being left out in the cold. And overall, I worry, as someone who cares deeply about religious exercise and religious liberty more broadly, I worry about the whole idea of religious freedom being politicized in the US and being used as a proxy for culture war battles and political battles.
That's a good lineup. Mark, go ahead. I think you're muted. We can't hear you. We still can't hear you. Oh, you're unmuted, but we still can't hear you. Go ahead. No. Let's go to Asma for a second, and we'll have Mark fix his audio. Asma?
Yes, thank you, Rachel. Thank you for this program. And I think maybe it was meant to be that Mark's mic wasn't working, because I think my list is the exact list that Dan just laid out for us. One, the scope of the Establishment Clause, which is not just at issue in the case that will be argued in front of the court in December, that involves school vouchers, which has come up in a number of other recent cases. But also we've seen cases related to large Christian crosses in public squares, legislative prayers, and it was all Establishment Clause was also at issue in the travel ban case, the case that challenged, for those of you who don't know, Trump v. Hawaii, the case where the state of Hawaii and a number of Muslim claimants challenged the travel ban that the Trump administration had issued against travel from a number of Muslim majority states. And in that case, Establishment Clause was also at, there was an Establishment Clause claim saying that the travel ban violated the clause because it was motivated by anti-Muslim animus, and the court rejected that claim. And so there's really a question across all these different contexts about what exactly the Establishment Clause means. And, you know, on the one hand, there are people, some are looking at this as a question of the Christian majority versus religious minorities, and a way that a number of these court decisions are essentially sort of allowing Christian symbols to predominate in the public square, for example, or, as Dan noted, treat different groups differently, some better than the others. I think my take on it, one of the things that I think is important to look at is also the way that these cases are trying to create clarity in an area that has been pretty muddled in terms of the jurisprudence. And so a number of groups have pointed out that one of the main Establishment Clause tests, the Lemon test, has for a long time just created a lot of confusion and leads the court into areas where it shouldn't be. And so there's been some push just from a question of like legal development and what the various groups and lawyers and advocates are working on is really trying to create clarity in the Establishment Clause space. And then another space is, I think anybody working in religious liberty right now in the United States will know about the conflict between religious liberty and various areas of sexual freedom, whether it be access to abortion, contraception, same-sex marriage, or a host of other LGBTQ rights. And I think that is one of the biggest, if not the biggest, areas of contention in religious liberty today. And then the question of majorities versus minorities is something that I'm very familiar with. As Rachel mentioned when she was reading my bio, I have written a book called When Islam is Not a Religion, which examines a claim that I first heard in the context of a court case that a Muslim community should not be allowed to take advantage of religious land use statutes in its attempt to build a mosque, because, and the argument went that Islam is not a religion, it is instead something else. In that case, it was argued that it is a dangerous political ideology, and therefore Muslims don't have religious freedom. And so while that's a really sort of explicit version, I think that there are elements of that and sort of like the foundation and the undercurrent to sort of the movement and the segment of people who think that religious liberty can be carved in that way, that I think is much broader and is something that is worrisome. And then altogether, I would say all these issues together point to the fourth issue that I agree with Dan on the politicization of religious freedom and the way that so many of these things are really kind of thought of as a question of a battle between the political left and the political right, as opposed to a fundamental human right that belongs to all people. Thank you.
Thanks, Asma. Mark, have we got your audio now? No, we still don't have your audio. Okay. All right. Well, we'll we'll see if you can log in somehow. But I think these are all really important questions, and there's no shortage of things to talk about. I want to get into a little bit more detail about when you talk about the Establishment Clause issues in a little while. But first, why don't we start with schools? As long as we've talked a little bit about schools, that's a big issue in the France panel, also an issue here. Whereas in France, the issue is here it seems like right now we have these cases coming up that are about funding of private, like whether you can wait a second, I have it like, so the Supreme Court on December 8th is going to hear a case called Carson versus Macon. It's about whether Maine can exclude religious schools from a state tuition program. And in agreeing to hear the case, Chief Justice Roberts said, a state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely because they're religious. And I think that this is something that's going to keep coming up. We see this a little bit talking about the larger cultural and political context in the Virginia governor's race. There are going to be issues COVID related about whether, there should be more subsidies given to or allowing people to send their kids to private school instead of public school. I want to just get your sense of what this case coming up means. What are the larger implications of that? Dan, why don't you start?
Sure, and I want to describe the case briefly, but first I just want to talk about it against the backdrop of a problem that I see as a persistent one in public schools in the U.S. Because I don't think we can think about the funding of private schools issue without also talking about what's going on in public schools. And one thing that I think is not very much part of the conversation these days is how much public schools are continuing to step over the line and violate the separation of church and state by promoting religious doctrine. And that this is an important question for the funding issue, because the question is what's going on in the public schools, and there's this view of what's going on in public schools, and particularly on the right, there are increasing attacks on the supposed indoctrination that's going on in public schools. But at the same time, despite the fact that there are over 60 years of clear precedent from the courts about what public school officials can and can't do in terms of promoting religion. And the basic rule is they can't. They can't favor religion, they can't promote religion. They also can't get in the way of truly private religious expression by students, but they have been crossing the line in many cases over the years. And we have brought a bunch. I can describe the details if we want to get into that, but we've had cases in Louisiana, Mississippi, South Carolina, Florida, where schools are going so far over the line to promote prayer, to read prayer over the loudspeaker, to have Christian prayer delivered by coaches and teachers fairly regularly. And these are rampant violations. The only reason why the courts aren't flooded with these cases is because it takes some courage to stick your neck out if you live in one of these communities and challenge it. So that to me is a big problem that is persisting. And so I'll now just lead in briefly to what's going on in the funding area, which was your original question. The case that the court is about to hear is a follow-up to several recent cases that the Supreme Court has considered on the question of when and under what circumstances may the government, or even must the government, provide taxpayer funding for religious institutions. And in this case, it's private schools in Maine. Now, for decades, the Supreme Court had taken a strong stand against compelled taxpayer funding of religion. There's a whole line of decisions restricting when the government could underwrite religious activities. And they're all drawing on clear concerns expressed by the founding generation that a crucial pillar of religious liberty is the protection against coerced financial support for religion. But in recent years, the court has not only relaxed those rules and opened the floodgates to this sort of government-funded religion that the founders were very concerned about. But it's gone one step further, and I think this main case, Carson v. Macon, is another opportunity for them to take a further step. And in my view, that would be unfortunate. It's gone one step further, and it's told states that not only may they, but they must funnel taxpayer dollars to religious institutions, even when their state constitutions say otherwise. And to me, that is an abandonment of core religious liberty principles, and we're going to keep an eye on what happens in this main case.
Asma, are you on the same page with Dan about this and about what he sees as a kind of overreach here?
So I have a different perspective on the various school voucher cases. But before I get there, I want to say that some of the dynamics that Dan was talking about in terms of what is going on more broadly in public schools, I think is an important thing to point out. And the angle that I've looked at it from is really sort of the disparity in how different religious groups are sort of thought of or treated in this context. And so there's a lot of anxiety that has been generated over the years. I mean, back to like the 1960s, when the Supreme Court held in one case, for example, that it was unconstitutional for state officials to compose an official prayer and encourage public school students to recite it. In another case, the court prohibited school-sponsored Bible readings in public schools. And specifically, it's important to note that the school-sponsored part is what's critical. Like you can read the Bible, you can pray, but it cannot be sponsored by the school itself. And this generated, as I said, a lot of anxiety that continues to this day. It's really been sort of perceived as the court kicking God out of public schools, and has been one of the reasons that many Americans have attributed for the American decline and for all kinds of other things, other problems and ailments in the country. And so in response to that, there's been a number of initiatives. There's, for example, a project called Project Blitz, that it is an initiative coordinated by 3 conservative Christian political groups. And it really is focused on sort of putting, I guess you can say, God back in public schools. I mean, I would argue God would never left public schools. But the various initiatives are part of the playbook for Project Blitz. Some of these things are the sort of series of legislations that we have seen, and to get the words "in God we trust" sort of emblazoned in sort of very prominent places in public schools. Like, for example, the hallway as soon as you step into it. There's been an attempt to institute Bible literacy courses in public schools. And we've also heard of these various acts called the Student Religious Liberties Act, which at its core is actually redundant because students have religious liberty in the context of public schools. But there's a need by these various sort of supporters of this initiative to kind of make that very explicit. And it's all sort of an attempt to kind of, and it goes back honestly to the earlier theme about the way that religion and religious liberty has become so politicized and is now this issue that is really at the center of this, political tribal fight. And Trump really seized on it. For example, former President Trump, where he said he was going to put prayer back in public schools, like this idea somehow that the political left is anti-religion and that the political right has to protect it, and propose various measures to make sure that it has a robust space in all areas in public space, in addition to public schools. And so, what's really interesting for me is that, concurrent to this phenomenon of putting God back in public schools, which I should be clear, I mean, there's this piece of this where I do support like broad religious liberty for students in schools, and, on its face don't have problems with phrases like "in God we trust." I think some of these other things, we certainly are a little bit more complicated. But I think for me, the irony really is that, again, concurrent to all this happening, there's also this tremendous fear and a push to kind of keep other religious students from being able to exercise their religious liberty in schools. And there are a number of nonprofits, for example, that, maybe I'll leave unnamed, that have literally been created specifically to make sure that Muslim prayer is not accommodated in public school, or if there's been a number of lawsuits against schools that have instituted anti-bullying programs that are in response to Muslim students who are being bullied, and these things are being challenged as favoring one religion over the other, or favoring in a violation of the Establishment Clause. And so I think that's been interesting. It's all this sort of like there's been situations where even sort of like a lesson in Arabic, like how to write certain things in Arabic, like has led to not just legal challenges, but even just emergency measures where schools have gone to lockdown. And so to me, it's really kind of like that, the disparity in the way that religion is being approached in this context that I find pretty worrisome. And then with respect to the Carson case, I have a different position on this than Dan does, in that I look at it more from the perspective of like, how are these rulings helping religion generally? And while it might be Christian schools that are the ones bringing these cases, ultimately the rulings, I think, are protective of religion broadly and can be of benefit to minority religions. And I think in Carson, again, the new issue that's being considered, whereas in the Espinoza case, an earlier case, it was whether or not a school voucher program can cut out religious schools simply because they're religious schools. So it was a status-based discrimination, the court said, in order for the state to do that. And now the sort of additional question, one that was sort of alluded to by Gorsuch, he said, there in the Espinoza case, so what exactly is this status use distinction? I don't really understand what that is. Like, is it it's okay for you to have certain beliefs, but you can't actually practice them? Like, what exactly is this distinction? And so that is the issue in Carson as to whether or not it matters that a religious school then actually teaches religious things, and whether a state can deny it voucher funding because of that. And I think, more kind of taking a step back, some of these issues involve, some people have argued that if to exclude a school because it teaches religious things constitutes religious discrimination, because incentives are created by schools, as schools are incentivized to either teach certain things because they're getting funding or not teach them, and that because they would be disincentivized from teaching these things because it would deny them the ability to participate in a voucher program, that would be something that constitutes government discrimination. And also there's sort of these tricky distinctions again between religious status and religious use. It's really, will the government protect you so far, simply because of the fact that you have certain beliefs, but if you start to implement those beliefs, the government can discriminate against you. So these are some of the thornier philosophical questions at issue.
Thanks, Asma. I want to step back just a little bit so we kind of understand a little bit better the context. So as I understand it, there was this earlier decision in Espinoza versus Montana in 2020, which argued that in which the Supreme Court ruled that the state of Montana can't exclude religious schools from receiving tax credit funded scholarships under its school choice program. So why is it taking this other case, Carson? And can one of you explain a little bit, like, what are the broader cultural implications of this? Are we moving in a certain direction? I mean, is there a way to understand some of the bigger cultural issues here, apart from the the finer points of each of these cases? Like, where are we going here? And maybe Helen has a point of view on this.
I mean, I think one thing that's certainly true is that we're seeing a real deepening of the culture wars, partially due to what you all have both pointed to, which is the idea that this has become a social justice. I mean, for the Trump administration, school choice was something that they were pushing forward and calling a social justice issue in a very kind of, vocal way, and something that, certainly is a kind of intensification, right, of the debates around school vouchers. But it does seem to me that part of the background of all of this is actually historical. And, I guess I would say that from the vantage point of someone who spends a lot of time thinking about political discourse in the contemporary US, like one of the reasons why so many public schools are seeing the kinds of incursions, Dan, that you're talking about is due to the kind of hyper-nationalistic rhetoric that we're seeing from people like, take a Steve Bannon, for instance, the notion that the Judeo-Christian West is under threat. Right, or that that builds into some really strong kind of anti-big government sensibilities that have been part of a real dismantling, right, of the public sphere, right? That also, I think, is happening coterminous with the sort of information age that we're living in, right? Which, among other things, is a kind of can be very deinstitutionalizing, right? So there are a lot of different ideas and critiques out there flying around, but it does seem to me that one of the most important things to keep in mind, particularly in a diverse democracy, is just that that for a very long time in early Supreme Court jurisprudence, up until relatively, I guess, the last 30, 40 years, I mean, we had Lemon, we had like the Lemon test, we had the Everson and McCollum decisions. We had these decisions that essentially were, according to critics of the period, really saying that the Establishment Clause was the controlling clause, right? That it was supposedly the controlling clause over free exercise. And the thing that I think is interesting about some of the work that I've done on that period is just that there's a growing concern in the late 40s and early 50s that in fact there is no such thing as neutrality, that free exercise should be the controlling clause. And so there's a kind of flip starting to happen ideologically in those middle decades that you see them played out over generations, right up to the point where we're starting to see arguments for religious freedom on the part of groups that we might call kind of majoritarian minority groups in a diverse democracy. In other words, groups that have large enough numbers of demographic representation to actually be a political force at the state or even the federal, at the national level. And the question of what's going on with that, I think goes back to this issue of the relative balance of establishment and free exercise claims. And I guess I would defend that characterization for an earlier generation where identity was less intersectional and argue that to a certain extent, it makes sense that non-establishment claims mean something to groups that have a chance of actually setting the tone religiously for their state or for their country, right? Than they do for groups that are so insignificant demographically that there's no chance that they will ever end up with anything other than a view of religion established somewhere that is not theirs. Right. And so I want to put that out there as an important kind of piece of this puzzle, because really, in many ways, the culture wars we live inside of began in the wake of immigration that changed a Protestant nation into a tri-faith or Judeo-Christian one. And I think we see the residue of that in the way that our contemporary political discourse is currently working, and in the way that the current religious liberty cases are being addressed.
That's really important context. Just, for those of you joining and who aren't First Amendment experts, we'll just summarize that, the First Amendment has the free exercise clause, which is the right to express your faith as long as it doesn't go against public morals or a compelling governmental interest. And then the Establishment Clause is basically what prohibits the government from establishing a religion. And as Heelan has explained, these two clauses have been in tension over the years. And now, I guess, Dan, how would you describe, where are we now in the history of the, tension between free exercise versus establishment? And what does that mean for, this particular moment and for the future?
I think we're at a crossroads. I think, at least when you're talking about the courts, but that spills over into the rest of government and beyond. It used to be the case that there was a well accepted, sometimes criticized, but generally accepted notion that the government should not be the one playing favorites with religion. The government should not be the one saying, here's what you should believe. That religion is right and that religion is wrong. And I think we're moving away from that in a number of dangerous respects. I think Heelan made a number of excellent points about sort of how the public views these religion clauses and these religious liberty ideals. We in some of these schools cases, just to stick with that example from earlier, where we've gone in and we've said, okay, the school, they've done the following five. They had a religious assembly where their stated purpose, this is a public school, stated purpose was to convert as many people as possible to Christianity. They read the Lord's Prayer every day over the loudspeaker. They had a giant cross and a portrait of Jesus on the walls of a public school. And when you ask some of those people, you try to get at, don't you care about this separation of church and state, this idea that the government shouldn't be playing favorites, and in this case, a public school is the government. What if, the question is posed, what if you were in a situation where you found yourself in the minority and someone was pushing another faith? And I think Asma raised a number of good examples of how Muslims in Islam, for example, are being treated poorly and differently and as some sort of threat based on nothing. What if you were in a situation like that? And the answer is often, well, I'm not going to be. At least it was in the past. That doesn't even cross my mind. I am in the religious majority, many people think, and therefore this doesn't bother me. It's okay for the government to put its stamp of approval on my faith. And that too is something that I think may be changing as well.
Asma, I'll ask if you have any thoughts on this. I'm sorry to say that Mark has been having microphone problems and is not able to log in at this point. So someone has to, we can't read his mind, but I think you might have some different points of view on this. Asma, do you have any response to Dan on that before we move on to the next question?
Well, I mean, I think that this question that the Heelan had raised as well about how the Christian majority sees itself as a minority is something that I've been thinking a lot about. It's actually the core of my second book, which is called The Politics of Vulnerability. And it came from this realization after the first book and detailed all these really extensive violations of Muslims' rights, or these calls for Muslims to be cut out from the protections of religious freedom. I was like, who's making those arguments and why? And many of the people, unfortunately, that were making those arguments were ones that were part of the Christian majority and were advocating for really robust reading of religious freedom for themselves. And so, I pointed out the hypocrisy there, but then again, raised the question of why are they doing this? And there's lots of very common reasons that people kind of throw out when it comes to the Muslim question specifically, such as Muslims are scary and they were perceived as security threats, and Islam is considered really dangerous. They say so very explicitly when they call it a dangerous political ideology. And there's also, of course, an element of racialization and racism, because Muslims, even though there's 1.8 billion of us across the world and we cover all races, we are seen as uniformly brown or non-white. And so those are all very important analyses. But the one thing that I called attention to in my book is the way that political tribalism in our current very exacerbated state of political polarization is playing into this. And the way that, for example, Muslims have become essentially conflated with the political left for various reasons that I can get into, and are perceived as sort of part and parcel of the liberal threat. And so, and then the reason why, they're a threat is because there's this feeling that the political left is suppressing the space, the Christian tradition and Christian beliefs and Christian practices from the public square. And this is something that's felt very acutely. If you talk to pretty much any conservative Christian, they will express some version of this. And it goes back to this idea of who are the minority, this question of who are the First Amendment designed to protect majorities versus minorities, but a very sort of palpable sense by many Christian conservatives that they are a minority and a very persecuted minority. And these places are their way of sort of being able to carve a space out for themselves in what they feel is an America that is fast changing.
I think that's a really important point. Who's the majority? Who's the minority? Who is actually a majority that acts like a minority? Who's a minority that acts like a majority? I mean, and in your book, you also make the point that evangelical Christians are, in fact, less than 50% of the US population at this point. So does that mean they're a minority? Not necessarily, but this sense of feeling kind of under siege in the larger culture battles is definitely something also that animates a lot of these cases. I mean, Asma, when you were involved with the Beckett Fund, Beckett defended the plaintiff in the Hobby Lobby case. So the company could get a religious exemption from federal anti-discrimination law and didn't have to provide birth control as part of the Affordable Care Act. And that's something I also wanted to raise. I mean, where are we in the kind of religious exemption universe? It seems like now with COVID, that's a huge debate. I wanted to ask Mark about that, but he's written about that, but he can't join. But I just wonder, from Hobby Lobby to vaccine exemptions, where, why all of a sudden are we just using religious exemptions for in so many different areas? Feel free to jump in.
Well, I mean, I think one thing that is really striking to me, and I'd be curious what Dan and Asma have to say about this. I mean, in my own research, I'm actually working right now on the sort of early history of what we call accommodationism or non-preferentialism. And both of those terms basically mean that free exercise sort of trumps establishment as a concern. In other words, the idea that you will accommodate religion or show non-preferential approach to religion. And the way that that people in the late 40s, early 50s, in the era of Everson McCollum wrote about this is they basically would argue that there's only one authoritative guiding principle of American church-state relations, namely that there shall be no established church, no state church, no organic union between the state and any one church. Now, the key here is there's not going to be exclusive support for any one religion. But I would argue that the sort of inroads that have been made by this accommodationist or non-preferentialist position, right, around this question of aiding all religions equally, the idea that that is possible and desirable, right? That is part of what's at stake in these contemporary debates. And you can see it even somewhat in the conversation between Dan and Asma, right? There's sort of a different, for Dan, the issue, right, is this question of what does it do to the public schools if voucher money is drained off for, to give school quote unquote choice, right? Asma, your question is, more or less we're focused on this issue of like fair treatment within the schools, right? The issue of whether religions are being aided equally or not. And so there's an axis kind of there around some of these issues, but I think these have been absolutely critical and defining questions. And of course, if you put those sorts of issues in a world that is now increasingly deinstitutionalized, like to our ear, what we hear is any one church. We don't think about religion that way anymore, right? As a purely institutional entity, not at the cultural level. I think it's certainly true that the courts continue to still look for religious organization. So like you can't make a conscientious objector claim, necessarily as a devotee of the flying spaghetti monster or something like that, right? Like there are limits to your ability to claim a religious exemption in the case where you can't prove that you have some kind of institutional or truly principled like reason, right? But it's certainly the case that among scholars of religion, the range of our sense of what counts as religion has become much, much broader, right? And that is coterminous with new ways of thinking about identity that are more flexible, they're more multifarious, they're less connected to institutional affiliation than they have been in the past, right? And that helps to explain some of what I think is going on. But it's definitely a fascinating moment. I mean, I don't know how many of you all in the church state realm and people that are interested in this question, right, saw the fact that Philip Hamburger, who wrote a very influential book about the separation of church and state some 30 years ago that was very strongly picked up in religious studies circles and has been widely used, right, has come out and basically said that he, raised the question of whether the public schools are unconstitutional. Right. And I think for lots of reasons, anybody that's ever come across that line of argument needs to think about the question of how we're doing history and, how it is that Philip Hamburger wrote a narrative in which the culmination, of this sort of long history of anti-Catholic bias was the Everson decision. Right. There's a much more complicated story to be told, right, about what church-state separation has meant in this country, I think. And I would really love it if, a future historian would really dig in there because there's more to say about that. But anyway, I'd be really fascinated to know what some of you all think about it. Mark, so good to see you.
Hi, I'm terribly sorry. I tried and tried and tried this. I told Rachel this mic was working for a meeting this morning and then it just stopped. But I pushed some buttons and now I think I pushed the right button. So I'm terribly sorry for missing this. I don't even know where you are in the conversation, but Rachel, I'm happy to pitch in wherever you like.
Great to hear you. Great to have you back.
Thank you. Thank you for having me. Thank you for having me.
Sure. Why don't we just dive into religious exemptions? You've done some work about this. And I think Keelan's point about Philip Hamburger basically saying public schools are unconstitutional because it's a whole complicated argument. But you've done some work, Mark, about religious exemptions and how COVID has kind of changed the landscape for that. And I just wonder if you could, we've talked about that for schools, but just dive in and tell us your
Sure.
thoughts on, my question was basically, why are we seeing religious exemptions all over the place? Why is this like now the button that everyone's trying to push?
Okay, good. So the first thing I would have said in response to your first question is that is the issue, I think, in church and state law in America today. It's precisely religious exemptions or religious accommodations. You see that across a whole range of areas. The Hobby Lobby case, I'm sure some people have mentioned this. I think Keelan mentioned contraception is the first thing she said, right? The contraception cases, the COVID cases, the wedding vendor cases, the vaccine mandate cases, and I think even the public school case coming up now is a religious exemption issue. It's being phrased as a free exercise case. We should be allowed to receive public funds in order to conduct religious education. So, and if you don't let us do that, this is the argument that is a violation of the free exercise clause. So I think it's all about religious exemption. Now, COVID, which you're right, I have written on recently, I think exacerbates this whole debate because, COVID is a worldwide emergency. Courts have to decide these cases very quickly without a lot of information. And so judges have to rely on their intuition most of the time. Do we think these restrictions are generally applicable? Is it fair to include churches among things that are closed, like theaters and lecture halls, or are they more like grocery stores or shopping malls or airports? Then if we get to strict scrutiny, right? I mean, is there a compelling interest in closing down or restricting churches when you are opening up other things? These are the kind of debates we're having. And I think precisely because things are so supercharged and it's an emergency and it's a life or death situation, it's become quite bitter indeed. And the last thing I'll say, and forgive me for, maybe everyone said this already, but the last thing I would say is it has become very politicized. You know, there's a study coming out in the Cornell Law Review, which indicates that in the COVID restriction cases, in like 100 cases in the last year, not a single Democratic appointed judge has ruled for the religious plaintiffs. And the Republican judges have ruled overwhelmingly for religious plaintiffs, not 100%, the way Democratic judges have ruled 100% against them. But Republican judges have lined up pretty much with the religious plaintiffs. And I think the religious fracturing that we're seeing is now entering our politics. And through the judicial confirmation process, it's entering our courts as well. So that's what I'd say.
And where do we go from here, Mark?
So
what are the implications of this?
Yeah, so I think the implications are we're in for some rough sledding for the near future. And I think it's because we don't really have a cultural baseline on a lot of questions, like the value of religious exercise in these situations, like the proper deference for public health authorities, like a lot of things. We're just very, very divided as a society. And because the law revolves around line drawing and balancing in these close cases, that lack of a baseline means you have really shifting decisions, unpredictable decisions, until we come to some sort of social equilibrium. I think when people look at the law, when they look at courts, courts reflect culture, and our culture is very divided right now. I think judges, in all good faith, I don't think these judges are acting in bad faith. I think they see things differently depending on which side they're on, and they reach different conclusions with respect to these things. So I fear until we come to some cultural baseline about these things, you know, what is the value of worship, for example, in a pandemic? You know, I think we're going to have really conflicting decisions. And one last thing, I heard what Helen was saying. I think you're exactly right. You know, the rise of the nuns puts a lot of pressure on this too, because now you have a lot of people who are defining their own religion, defining it for themselves. And now the courts are going to have to deal with those claims of religious exemption too. You know, there was a case a few years ago from Virginia in which a psychic, a spiritual advisor, tried to get a religious exemption from zoning rules. And the Fourth Circuit said, you're not a religion. You're not a member of any organized religion. You don't have a tradition. You know, you don't get this. And well, that's a controversial issue too under our law, whether she should have or not have. And I think that's going to become much more important too. But I don't want to talk too long because maybe everyone said this already, but those are my views.
No. Thank you so much. It's great to have your views. I want to remind the people listening that you should please feel free to write in questions in the Q&A function. And in a little while, we'll get to some of those questions in our remaining time. Cultural implications of legal decisions, politicization of courts. This brings us to an inevitable question. I want to ask each of you your thoughts on what the current makeup of the Supreme Court now will mean for religious liberties questions now and in the coming years. Why don't we start with you, Dan?
All right. And Mark, no need to apologize. I think you're owed extra minutes here anyway. So, I think, you know, as I mentioned at the outset, I think the court is moving in a very clear direction, which is almost no concern for the separation of church and state, and an overwhelming concern for free exercise, which again, I don't think is inherently bad unless it's coming in situations where other people are getting harmed by the invocation of the free exercise right. Just to build on what Mark just discussed about COVID, we've seen a steady increase in the court accepting, honoring, granting claims for religious exemptions in a lot of situations that a couple of decades ago it would never have done. Exemptions to civil rights laws, anti-discrimination laws, things like that. I think the COVID situation may at least be a bump in the road for those traveling on that path, because first we had a wave of decisions about assembly restrictions, how many people could gather in one place. And even there, the court, the current court, which actually switched while these cases were going on, the current court, at least the majority of the court, was receptive to the idea that houses of worship should get exceptions simply because a grocery store also has an exception, treating those things as the same. But I think with the vaccine mandates, we might, like I said, there might be a pause here. We have one recent data point from the Supreme Court, which is they refused to step in and stop a vaccine mandate for healthcare workers in Maine. And there are many other cases that it's going to be thinking about and considering, including a couple of New York cases. And there the court denied the request to put a stop to the mandate, at least for those with religious exemptions. They denied it 6-3. And I think one of the concerns that may be animating something like that is the prevalence of political objections masquerading as religious objections. And I know that there are those who are very strong advocates of religious exemptions, even in the civil rights cases, who are worried about what seems to be the prevalence of these claims, and many which are facially fraudulent in terms of whether or not they're religious. I mean, it's people who don't like this, and then they turn around and they say, you know, it turns out this violates my faith, even though they are taking many other actions and many other medications that seemingly they should have the same objection to. Now, I don't mean to suggest that everyone with a religious objection falls into this category, but I think there's a growing concern that this category is getting larger. And that may be one thing that at least puts a pause to this march toward unfettered religious exemptions.
Thank you. Mark, we'll go to you again since you're catching up, and then we'll get to Asma and Helan.
Okay, thank you. Thank you.
The Supremes and
Supremes. So I agree, by the way, about the vaccine cases. I think you may see a pause there. So my guess for the future with this court is that it's likely to be moving in a pro-exemption direction, but I think it will be slow. And I think the decisions will be narrow. And the reason I say that is, if you look at the cases that have come up in the last few years, like Masterpiece Cake Shop, in which the court said that the baker could get an exemption, did not have to abide by the public accommodations law. If you look at the Fulton case from last term involving the Catholic Social Services Agency, where the court said, again, that the religious plaintiff should get an accommodation, these were very narrow, fact-specific decisions. The court had an opportunity to turn over the whole apple cart in Fulton. There was a request to overrule Employment Division versus Smith. I'm sure you've talked about that already. And the court didn't do it. The court, and there was some frustration on the part of conservatives like Justice Alito and the others who wrote a concurring opinion, which looked like it was a majority that became a concurring opinion, looked like something flipped. They weren't going to do it. And so I think they're going to go slowly down this path. So if that makes you feel better or worse, I don't know, but I don't expect big, huge pronouncements on this.
So we didn't actually talk about Employment Division versus Smith, which basically said the state could deny unemployment benefits to someone who was fired for violating a state prohibition on the use of peyote, even though it was part of a religious ritual. And this is a 1990 decision that kind of set precedents. But yeah, so we didn't so much get into that, but I think that helps put your comments in context if everything is super narrow. But why is it that the court doesn't necessarily want to take on some of the bigger issues and is sticking to much more technical procedural questions?
So is that directed at me, Rachel?
Sure.
So I don't know. I assume they might think these problems may go away in time as the culture reaches a new equilibrium. They might think that they're already kind of under the spotlight and they don't want to make broad pronouncements. And they also, Justice Barrett in the Fulton case said, if we get rid of Smith, so the thing about Employment Division versus Smith, it says if a law is neutral and generally applicable, there is basically no right to an exemption from that on the basis of religious belief, which is why it's really kind of cabins religious accommodation. And Justice Barrett said, if we get rid of that, what are we going to come up with? We're going to have to come up with a new test, which will be problematic too. So those are the reasons I think they don't want to move fast, but I could be wrong about that. That's just my view.
Fulton case said that a Catholic social service agency in Philadelphia could refuse to work with same-sex couples who applied to take in foster children. And always the idea is like, well, they could go somewhere else. And that opens up a whole other issue. Helan, why don't you tell us your thoughts on the Supreme Court and on some of these other issues that are on the table now?
Well, it's interesting. I mean, I think, I think that one of the things about the deepening of the culture wars is that it can go, I mean, we really are seeing in our political life a kind of swinging pendulum kind of situation, right? And, we can call certain things politicization and other things just a sort of intensification of the sides or whatever you want to call it. But it seems to me that anything's possible in an environment like that, right? And so I hesitate actually to do much in the way of predictions about where this is going. I do think it's instructive though. I mean, I remember reading an article at some point that said something about, under John Roberts, like 81% of the cases on religion have gone, in a sort of pro-conservative direction, or in the direction of this particular reading of religious freedom. And if that's any predictor, I'd say, that's not an optimistic track record for anyone who finds that problematic. So I guess what I would say about my own sort of academic work is just that I hope other people will join me in paying closer attention to what we might call sort of the widespread sort of religio-political discourses that sustain the world that we work and move in, right? And that includes, of course, the Supreme Court justices who write decisions and use words like secularism and, accommodation. I mean, they use they talk about what religion is. They're like debating that question of what religion is. And it does seem to me that we can get a lot of clues from looking. I mean, I guess what I would end with this, one of the things that was really surprising to me in this book that I wrote about Judeo-Christian discourse is that everybody thinks of the 50s as this period where, one nation under God, like the sort of Eisenhower, like push for, for this kind of Christian America, or the idea of a, Judeo-Christian kind of tri-faith America as the reigning image of the 50s. Well, it turns out Eisenhower was actually not the most prolific user of Judeo-Christian terminology among the presidents. It was Ronald Reagan. Right. And I mean, by vast amounts, vast amounts. Right. And so even though in our minds, we have this idea that there's this kind of moment of a making of a tri-faith America from the late 30s to the, mid 70s, when people on the left start to say, hey, that's too narrow an understanding of this nation's identity. Right. It is actually the 80s, like when it becomes enshrined in our sort of religio-political discourse. And the thing that happens alongside it is a lot of use of what we would call kind of anti-secularist. I mean, Reagan is really attacking secularism, right? Which for him is a copious reading, right? I mean, it's like the Ann Coulter reading, Godless, the Church of Liberalism, right? I mean, secularism can be expanded outward to be something that includes all manner of religious groups, or it can even do, in the case that you pointed out, Asma, the work of basically saying this isn't a religion, it's a political view. Right. I mean, there's a lot of like potential movement in and around inside demonization of secularism, but it's part of the discourse of Judeo-Christian America on the right. And the fact that Trump was able to be elected in this country with the help of someone like a Steve Bannon, who has a message not just for this country, but for the world, right, around the idea that what ought to be happening is a certain kind of return to a particular style of bounded sort of blood and soil nationalism with religion at the center, right, and that is a project worldwide. Right, because of the threats to the Judeo-Christian West. Like, I think we need to be paying a lot closer attention to discourse, I guess, is what I'm saying, because when we do, and to the meaning of words in context, I'm really on board with what Joan Scott said about how, laicite or separation of church and state, it's not just that it's true that it has certain meanings in different historical contexts, it's that it's literally true in the context in which a speaker uses it. Right? And so we need to be real careful about kind of teasing some of that out and seeing how these discourses work in our political lives. That would be my sort of caution, but no prediction here.
Thank you. Asma, what about you? What do you think about how the makeup of the Supreme Court, what that'll mean for religious liberties questions?
Sure. So first, I want to say I absolutely agree with the question of discourse. And it's something that I, have stepped out as a lawyer, have actually stepped out from the purely legal space and been really sort of fascinated by what's going on socially and culturally. And I think that's a huge part of what religious liberty is today. I also wanted to add on to something that Mark had brought up. Mark, the study you mentioned, which I think I have the same one in mind, not just found that Democrats had ruled 100% of the time against the religious exemption to COVID regulations, and Republicans appointed judges ruled in large part for them. But specifically, I believe that study also looked at Trump appointed judges and found that there was an even higher percentage there in terms of their ruling for the religious entity. And so that just, for me, underscores the political elements of this. I mean, Heelan also mentioned the recent studies by, for example, Professor Lee Epstein that have found sort of really high rate of pro-religion rulings under the Roberts Court. And then even a much older, a study that looks at like the early 2000s. This isn't something in some ways that's new. I think it's just become exacerbated. But other studies, for example, have looked at Republican versus Democrat appointed judges and their holdings in cases involving the Establishment Clause. And I think this is relevant because we brought it up in this talk a number of times, that if you're a Democrat appointed judge, you're much more likely to hold that there's been Establishment Clause violation as opposed to vice versa. In terms of the current makeup and a future outlook, I agree with Mark in terms of the narrow rulings that we've seen in Fulton and Masterpiece and elsewhere. I think there's also a very much an understanding of the fact that their religious liberty is so core to our culture wars right now and to our political polarization. I think the court is very sensitive to that. And so you've seen a number of statements in a number of different cases where they're trying to kind of navigate this indirectly, whether it be in Obergefell, the case that established a constitutional right to same-sex marriage, or Bostick, which expanded LGBTQ employment rights, and saying that even as we're holding for the LGBTQ rights issue in this case, we want to make a point to say that religion is also really important and shouldn't be demonized. So we see the sort of way that the court is negotiating these elements, not just in terms of the narrow rulings, which I think is a function of that desire to kind of give society a space to come to conclusions or solutions on its own, but you also see this sort of explicit language. And then the other thing I just want to point out is something that I've been exploring in my own work, is the way that this sort of deep anxiety around the role of religion in this country and the desire to both minimize political tribalism around religion and also create a really sort of robust space for religious exercise might create interesting opportunities where the court's going to begin to think about cases involving non-Christian believers in line with this view. And the case that kind of inspired this for me was a case decided in December 2020, and it was called Tanzan v. Tanvir. It involved 3 Muslim men who were being coerced by the FBI to spy on their religious communities, and they refused to, and said being coerced into this is a violation of their rights under the Religious Freedom Restoration Act. And you saw a unanimous ruling by the Supreme Court, the opinion written by Justice Thomas, who usually doesn't really take the pro-civil rights position in national security cases or in cases involving sort of national security implications, and in favor of the Muslim men. And what was at issue? At issue was this really sort of broad protections and the ability for religious claimants to seek money damages under this statute. And the possibilities there for Christian claimants are pretty clear. And so I thought that was an interesting case where the same anxieties that some of the justices might have around Christian rights might actually end up leading them to produce rulings in cases that maybe sometimes they wouldn't have been inclined to.
That's a really fascinating case example, and where what one would think the ruling would be turns out to be different, a little more unpredictable. We have one question from the audience. If anyone else has any other questions, they can write in the Q&A. I thought I'd just throw out the one question we have, which is that religion has been weaponized to support culture wars. Who among US religious leaders is standing up for the firewall between church and state? I don't know if I have an answer to that, but maybe some of you do, or if you have some thoughts about that issue before we wrap up on the culture war context. Anyone?
I'm not going to mention any specific names, but I think you'll see in cases, particularly when they reach the Supreme Court, you'll see these group briefs, amicus briefs or friend of the court briefs. And oftentimes you will see collections of religious leaders actually on all sides of all issues. This is sort of a regular practice at this point, that whatever side you're on, you try to get a brief, at least one brief of religious leaders to support your view. So there are definitely many out there, religious leaders who vocally and strongly support the separation of church and state, and who believe that it is essential not only to protect government, but also to protect religion.
Thanks. Anybody else?
I would just add, I mean, it's not so much in terms of the church-state wall, but I think a facet of that, this insistence, certain religious leaders have really kind of insisted on religious liberty for all, the equal protection of all religions, and not, favoritism for one religion. And so in that regard, if we're going to name names, I think, for example, Russell Moore is one of them, who's really kind of taken heat from his own sort of Southern Baptist, congregation for sticking up for the rights of Muslims, for example.
I mean, I guess I would say that the question is sort of emblematic of what I was saying before about the deep divide here, because you could characterize this as religion is being weaponized, but I'm sure if you talk to many people who are religious conservatives, they would say they're defending here. They're the victims. They're not looking for these fights. These fights have been brought to them. That's what they would say, and I think they believe it when they say that. So my comment would be that's an example of the polarization that is driving a lot of these cases, I think.
Well, and I would add, Mark, I think that's such a good point. One thing that I've been teaching a course on called the liberationist turn, that's about the sort of move to liberation theology. And one thing we talk about a lot is this question of freedom, right? Not just as it relates to religious freedom, but the sort of wider question in theology. And it's sort of fascinating because, I mean, one thing that we keep coming back to, which I think is applicable to this debate, is this question of whether there's a vision of this country or, of the free exercise of religion in which everyone can fully actualize their own free exercise without actually getting into a situation where one person's free exercise is another person's loss of their rights, right? Because I would say that we're actually at a point right now where we're seeing more and more the idea that just sort of boundless visions of freedom for each person to kind of do their thing, right, can lead to a situation where we have absolutely abject conflicts in rights claims. Right. And so it's a little bit like the sort of, self-actualization. Like if everyone just self-actualized, the world, would be fine. And the sad fact is that people's visions of what that's going to look like will come into conflict over resources and visions of the good and the public sphere and all of those things. Right. And so, I'd say in that sense, we are in for a rocky road ahead, potentially trying to sort all of that out. Because I think we're going to see more and more of those kinds of conflicts, where, as you say, from the perspective, I mean, there are weaponization stories on both sides, right, in this present climate.
Thanks so much for that. This is an intense note to end on, but I want to thank all of the panelists. This has been a really fascinating discussion about religious liberties questions in the United States, the rights of religious minorities and majorities, and who's the minority and who's the majority, and where do we go from here? It's we haven't quite figured it out, but it's been a terrific conversation, and I've learned a lot from all of you. So thank you, Helen and Dan and Asma and Mark, for joining. Thanks everyone for as part of the SNF Agora Institute team.